Hi, my name is Carter Clues, and I am today the guest host of Inside Judicial Watch. Regular host Jerry Dunleavy, who does a great job, is out today, and I am privileged to be here with my good friend and colleague and esteemed attorney for Judicial Watch, Michael Bekesha. Michael, welcome to Inside Judicial Watch.
Thanks for having me, Carter.
It's my pleasure, and what we're going to talk about today is not what I would call a pleasure, but it's certainly an important topic, and I know it's one of great concern to the supporters of Judicial Watch, and rightly so.
And probably the American public at large as well.
Yes, I think you're exactly right, the American public at large. Peter Strzok and Lisa Page became infamous for their, look, I'm just going to tell it like it is, their tirades against Donald Trump, and apparently their orchestration of a pretty serious campaign during the election and since against the President of the United States. You have filed a very important lawsuit relating to Mr. Strzok and Ms. Page. Can you describe what that lawsuit is for us, please?
Sure, absolutely. So it's actually fairly simple. You know, we've learned through the media, through leaks, through Congress, that Peter Strzok and Lisa Page communicated a lot. They sent a lot of text messages they were both on the Clinton investigation, and then they both had some role in the beginning weeks of the Russia collusion investigation. So probably the two most important investigations the FBI has undertaken in at least a decade, if not longer, they were involved in. We knew they were communicating. So what we did was we sent a Freedom of Information Act request to the FBI asking for all communications between Peter Strzok and Lisa Page. That is emails, text messages, personal email, emails about work on their Gmail account. They apparently were using iMessage, which is an Apple platform. So we asked for all of those for the approximately 2-year period that the Clinton investigation and the Russia collusion investigation was going on.
And let me make the point here, and I think you agree, these two people were not just ancillary to those two investigations. They were key players in both the Clinton investigation, the very fraudulent Clinton investigation, and they were key players in the Trump investigation. So they weren't just people who were casually stopping by, correct?
That's correct. They were senior level folks. They were involved. Peter Strzok had some decision-making capability. Lisa Page was an attorney that was reporting to and working with senior level officials at the FBI. So they just weren't lower level agents. They had supervisory positions, and they were real players. They
were real players. If I'm not mistaken, they were both members of Comey's skinny group that met privately to come up with the strategy for both not going after Hillary Clinton and going after Donald Trump.
You know, I know that's true for Peter Strzok. Lisa Page, maybe not as much, but I know she was involved in a few meetings.
And Mr. Strzok, if I'm not mistaken, is the man who changed the wording of Comey's July 5th statement where he essentially exonerated Mrs. Clinton.
I believe he changed some of that wording.
He changed the wording and got rid of the words gross negligence, which under U.S. Code is a indictable crime.
It was. I think we've seen some of that. We've received some of those, related to the Clinton investigation. Judicial Watch is still in ongoing litigation asking for all records about the FBI's investigation into Hillary Clinton's use of a personal email account and server. We've been getting monthly records for well over a year now. Probably a little bit more than that if I'm starting to lose track of time. But we keep getting them. They're getting close to completing that. But, we're going to see more and more as we get more records there. But with Peter Strzok and Lisa Page, look, we want the communications. We want to know what they were talking about, when they were talking about it, and what influence their conversations had. So we sued. We sent a FOIA request. Not surprisingly, the government didn't respond. So we sued. And we learned that there are at least 13,000 pages of communications between just the two of them. So that's not
13,000 pages. Now, is that 13,000 pages, the text messages and emails, or emails alone?
It's emails, text messages, and any potential attachments to emails. But what I want to make clear is that just wasn't, emails that both of them were on. That, they were sending an email to their whole investigative group, or there was another colleague on it. These are only emails and text messages that the only two people on them are Lisa Page and Peter Strzok. And so there are 13,000 pages. We were told that the FBI can only process 500 pages a month. We received our first production, which was about 87 pages. And so we're going to be litigating with the government for at least the next 2 years before all of this information is made available, which is really surprising. You would think that the Trump administration would want this information public, but they're slow walking and they're stonewalling just as bad as the Obama administration was when it came to these specific records.
Now, when you say the Trump administration, actually, there are two people who could order these released and order them released expeditiously, if I'm not mistaken. One is the president. Mm-hmm. The other is the Attorney General. Is that correct?
The Attorney General, the FBI Director, both who were appointed by President Trump. Absolutely.
Both Wray and Sessions could say 500 a month is not enough in a case that may involve an attempt to interdict a presidential election. They can say that, and they're simply not doing it.
They could say it, and so could President Trump. What is so surprising is we keep having these, I'll call them political theater up on the Hill, right? These congressmen call in Peter Strzok, and he sits there for 11 hours and testifies. We learn a little bit, but we don't learn much. How are we going to learn what really happened? By seeing the actual communications, by seeing the records, seeing firsthand what they were saying and when they were saying that. And one way to do that is for all this information to be released to the public sooner rather than later.
Michael, we have an advantage here because you not only are the lead attorney in trying to get this information, you're also an expert on FOIA, You teach on FOIA, you help other people understand how to do it. And this may be a stupid question, but can't Congress get this information? Can't they force the Department of Justice? Don't they have oversight?
So it's funny. Well, it's not really that funny. It's actually a serious matter, but I've been at Judicial Watch for 9 years. I've litigated just about 100 FOIA lawsuits during that period of time. And I can tell you from my experience, Judicial Watch using the Freedom of Information Act is more powerful and more successful than Congress. Congress, when they subpoena, when they use their oversight powers, that's a political process. The executive branch can ignore them, doesn't need to follow, doesn't need to provide them what they want, and Congress kind of is stuck. Judicial Watch, we don't get the records, we can sue in court and force the judiciary to take a position and enforce our rights. We saw this time and again. We saw this with the Hillary Clinton emails, and we saw this going back to Fast and Furious. President Obama claimed executive privilege over 50,000 or so records. Congress subpoenaed it. They held Attorney General Holder in contempt. They sued over it. We sent a FOIA request for the same records. We filed a lawsuit over the same records, and the records were released to us before they were released to Congress. In fact, the judge in our case, when he ruled a couple times about getting an index of what was being held, was, well, if I do that here and Judicial Watch makes it public, that may speed along the Congressional Congress versus executive branch lawsuit. So, Congress can conduct its oversight, but when you really want real oversight and you really want real answers and real action, come to Judicial Watch. We can do it better.
I'm going to say something which I know will echo how our supporters feel. It may sound odd coming from somebody who works here, but thank God for Judicial Watch. Because you do, thanks to you and the other attorneys here, You don't stop. You persist and you persist. Let me ask you a question.
And just to stop right there, I mean, we have attorneys on staff that do this, but we also have a research and investigation department run by Chris Farrell. And, they send out, could be hundreds of FOIA requests every week. They're continuing to figure out where the issues are and what we need to be asking for. So it's because of their work, it's because of my colleagues in the legal department, and of course because of all our members, we're able to do this great work.
And for me, I do communications. I don't do any of this stuff.
No, we just make you look good.
That's exactly what you do, and I appreciate it because the work that you do, you mentioned the Congress held the former Attorney General in contempt. Mm-hmm. And so I imagine he was in pretty bad trouble for that. Is that right? What happened then? Did he go to jail? Was he stripped of being attorney?
No, nothing happened. He got to continue going on his way. It's very much, during the oversight of the Clinton investigation and the Brian Pagliano didn't show up, was subpoenaed to testify before Congress. Brian Pagliano, who helped create the server, Hillary Clinton server, didn't show up to Congress. They held him in contempt. Nothing happened to him. He just blew him off, and they didn't seem to care. And that's why it was, I was curious to see what was going to happen last week. There were some rumors that Lisa Page wasn't going to show up.
Right.
And they were going to say, oh, we're going to hold her in contempt. Well, to this Congress, it doesn't do anything. They don't use their jail that they could lock somebody up. They could send it to the Justice Department to enforce it. Justice Department usually doesn't take action. So it's all political theater. When you want oversight, when you want accountability, when you want to know the facts, you come to Judicial Watch.
You come to Judicial Watch, and thank goodness you follow up on it. Let's talk about that, the testimony. I know it's not directly part of the lawsuit, but if there's any expert on this, these two people, Strzok and Page, it certainly is you. You've done your homework on it. You have the lawsuit that eventually will expose a tremendous amount of what they did. He's testified now in what, frankly, I found to be one of the most egregiously arrogant and disrespectful acts that I've ever seen. Now, I go back to the McClellan hearings, so that's a little while back, when they interviewed Sam Giancana, the head of the mafia, and the other even they were not as arrogant and disrespectful. They didn't roll their eyes, they didn't smirk, they didn't giggle. Well, actually, Sam Giancana did giggle at one point, and Robert Kennedy was, unfortunately for Giancana, was questioning him, and he said he absolutely eviscerated the man, something we didn't get to see, unfortunately, when Strzok pulled the same stunt. What did you, as an expert on very much of what these two have done, what did you think as you were watching that testimony?
We didn't really learn anything. I mean, this goes back to my statement that it was political theater. Congress asked some questions. Mr. Strzok didn't answer them. He answered what he wanted. He was able to provide non-answers. We didn't learn anything. I've heard that Lisa Page's interview was a lot better, that Congress actually learned information because it was private. The TV cameras weren't on. But again, what do you expect when you provide somebody, you say, you wrote this, should you have written that? Of course they're going to double down and they're going to say, well, that's not what it means, or that's not a reason to be concerned. And so I'm not surprised by Peter Strzok's attitude or answers at all, but that's why we need the records. That's why Judicial Watch is suing to get the communications, to get all of the emails, the 13,000 pages of emails or text messages, because that's going to tell you the full story. The full story is going to be in the paper. It's not going to in the record. It's not going to be in testimony after the fact when individuals are trying to defend themselves.
You not only are an attorney, a very astute attorney, you're also a very bright person, a person who I think is a pretty good judge of character.
I should come on the show more often with you.
I think an attorney has to be a pretty astute judge of character, because you question people, you have to evaluate their responses. Do you for 1 minute believe Mr. Strzok's contention that his absolute disdain and hatred for Donald Trump had no impact whatsoever on his behavior? Is that believable to you?
It's a great question. I mean, I can see circumstances with certain individuals where that could be possible. I think that's what law enforcement is trained to do. It's what lawyers are trained to do. You separate emotion and you look at the facts. I think my family and friends say sometimes I see things too much like the law and,
Right.
don't have the emotion attached. However, I'm not sure we see that with him. I think that testimony was clear that he's emotionally involved in the investigation, in his work, in his personal life, and I think those emotions got the best of him. So going back to his demeanor and why you see different demeanor from other individuals that testify is because he's too emotional. And so I think it is very difficult to say that he was able to separate his personal feelings, his emotion, from the work he was doing.
I don't believe for 1 minute that when he said, "we'll get him," that there was no emotion, and as he told us that it meant the world will get him. Well, it's pretty arrogant to speak for the whole world in the first place, but I think he can speak for himself. And in my opinion, that was pretty clear-cut in the context of that text message exchange.
Yeah, and the other interesting thing about the text messages that have been released to the public slowly, but some have been released, is the fact that in the text messages, the two individuals, Page and Strzok, talk about communicating not just on their FBI phone and their FBI email account, but also on personal email accounts, on their Gmail accounts. And so Judicial Watch, is sick and tired of these government officials using personal email accounts to conduct official government business. I mean, Hillary Clinton did it, but so did Jim Comey. I mean, we've seen
exactly.
The IG report says that Comey used Gmail on occasion for work-related business. No one is probably surprised to know that Judicial Watch has a lawsuit about that as well. And we're going to get to the bottom of that. But with respect to Page and Strzok, we don't know if the FBI has asked for those emails from them, the ones from their Gmail account. We don't know if they are being preserved. And so Judicial Watch in our lawsuit have also filed a motion for preservation. So we want the federal judge in Washington, D.C. in that case, to order the FBI to make sure to take necessary steps to ensure that Lisa Page and Peter Strzok do not delete any work-related emails on their personal email account. And in response to this motion, the government said, well, these are former senior level officials. They need to be provided. You can trust them. They're going to do the right thing. And in response, we said, these two individuals, no, they don't get the benefit of the doubt. It's time for the Justice Department, for the FBI, to go make sure to take whatever steps are necessary to ensure that they are not deleting emails and text messages about the investigation that they did on their private phones and their personal email accounts. Because that's where the good stuff's going to be.
Right.
I mean, as we learned with Hillary Clinton and the Clinton Foundation, all the good stuff is not going to be on FBI machines because these people are too smart. So we want access to those. We want to make sure they're not deleted or lost or destroyed or whatever else could happen. And so we're pushing that angle too. There's a lot going on.
Great.
We keep busy, and it's great fun.
And I think I speak for all our Judicial Watch supporters when I say thank you very, very much for what you're doing. Thank you for filing these suits. Thank you for persisting in them. Thank you for being on top of your game day after day, because it's a great relief to all of us. And thank you for joining us in Inside Judicial Watch, and we'll see you next week.